To this presentation. My name is Samantha and I will be doing a presentation on abortion in America. So I'm going to give a little brief history of abortion, and then I'm going to go into the importance of the judicial system with abortion, the importance of Roe v. Wade, and also several key players in the abortion and anti-abortion movements in their respective movements, as well as what is happening right now in regards to abortion in America. So let's begin with the history of abortion. So in colonial America, abortion was not only legal, it was condoned, safe, and practiced often. The procedure wasn't done in shady back alleys. In fact, abortions were practiced by established doctors and midwives. Abortion was legal before quickening, which is when the mother can feel the fetus move, typically around 4 to 5 months into the pregnancy. Despite the Puritans' oppressive reputation, they actually condoned abortion as long as it was before this quickening stage of pregnancy, which is where the mother could feel the fetus move. So skilled midwives would remove fetuses using herbs and other natural treatments as inducers. Surgical abortions were rare and dangerous as the country had not yet developed proper procedure for that process. One of the first and most prominent cases that has to do with abortion is that of Sarah Grosvenor. In 1742, Sarah Grosvenor attempted an abortion non-surgically through a medication, but the medication caused her to fall ill, and as a result, she had a doctor perform a surgical abortion on her. She died a month later due to an infection caused by the abortion. 5 years after her death, the doctor that performed the surgery was charged with performing an abortion after the quickening stage. As there was only a charge on these technical terms, the case furthered the notion that there was no ethical implications for abortion in general. So that was the first really prominent case that had to do with abortion, but it was just about surgical abortion. So as the century turned, Victorian values were brought into the United States, and with this brought further independence for women. Now women would leave the house for church groups, and upper-class white women would use abortion as a way to limit family size and conceive at an older age. Seeing that women are gaining a newfound independence over their bodies, men did what they always do, ruin things for women. So in the mid-19th century, as industrialization changed America, medical physicians began to move away from so-called irregular medical practices, those that midwives and homeopaths partook in favor of male-dominated scientific medicine. In 1869, the Catholic Church banned abortion in any stage of pregnancy, and in 1873, Congress passed the Comstock Law, which made it illegal to distribute contraceptive drugs through the United States mail. By the 1880s, abortion was completely illegal in the United States. This anti-abortion movement, led by male doctors and legislators, painted women who had abortions as selfish, while claiming that women who didn't have abortions were godly. Restricting abortion was simply a control tactic disguised under the thin veil of moral obligation. Due to the actions of these scared men, abortion was made into a criminal offense. Fast forward almost 100 years, and we're in the 1960s, a time of justice, change, and movements towards equality. With uprisings related to abortion being illegal, the Supreme Court began to rethink cases that prevented contraceptive distribution to married couples, and later, to single couples. Real change was not enacted until the landmark case Roe v. Wade in 1973, in which the Supreme Court ruled that all women had the right to terminate a pregnancy until the fetus is viable outside of the womb. Now, I'm aware that this court case is thrown around in current conversations surrounding abortion, so I'm going to give a brief history on the case itself. So Jane Roe was the pseudonym of Norma McCorvey, a young woman who sought an abortion. Due to its illegal state, she had tried to get the abortion illegally. This failed, so she reached out to the Texas attorneys Linda Coffey and Sarah Weddington, who were both interested in challenging anti-abortion laws. The attorneys filed the case against Henry Wade, the district attorney of Dallas County, where McCorvey lived. On January 22nd, 1973, in a 7-2 decision, the Supreme Court ruled in favor of Roe and every other woman that has had to have an abortion or struggle due to the abortion ban. The court declared a woman's right to her body through abortion was implicit in the right to privacy in the 14th Amendment. The court divided pregnancy into 3 trimesters and decided that in the second trimester, abortion could be regulated but not banned, and that could affect, usually would be in effect to the woman's health. In the third trimester, the court could prohibit an abortion unless the mother was in dire need of medical assistance. But in the first trimester, they could not limit abortion at all. Norma McCorvey became an active member of the abortion rights movement, but actually in a twist of events, she converted to Catholicism in the 90s and became an active opponent of the procedure. So there's definitely a dichotomy there that has a lot to do with how America has changed over the years. Interestingly enough, before Roe v. Wade, Republicans and Democrats voted equally against abortion. It wasn't until the 1970s when Richard Nixon campaigned heavily against abortion in order to win Catholic votes that the tides turned. So Republican senators began to use the same tactics as Nixon when running for office, and since then, anti-abortion has been on the platform for every Republican nominee since. So let's get into some notable cases since Roe v. Wade. A lot has happened in between Roe v. Wade and now. So that being said, Roe v. Wade did not close the debate about abortion. So here's a little bit of information about the major court cases post Roe v. Wade on the subject of abortion that have to do with our current events today. So first off, we have the case of Doe v. Bolton in 1973. That established that the woman's right to an abortion could not be limited by the state if it affected the woman's health. So the health was described as all factors, physical, emotional, psychological, familial, and the woman's age, relevant to the well-being of the patient. In 1976, the case of Planned Parenthood versus Danforth ruled that a woman needs written consent from her husband if married. If unmarried and younger than 18, she needed written consent from her parents. This was called informed consent, and it stayed around for a while, and it's still around in several states today. Harris versus Mcrae is another important case from 1980. That upheld the Hyde Agreement, which restricted state funding of abortions, except for in cases where the mother will die of the abortion. This was changed in 1994 to allow for funding for cases of rape or incest, but it's still around in many conservative states. Many states in general, actually. So in 1992, a very pinnacle case, Planned Parenthood versus Southern Pennsylvania, Planned Parenthood of Southern Pennsylvania versus Casey, redefined several of the provisions that were made in the previous years. This included the waiting period, spousal notice, and for minors, parental consent prior to undergoing an abortion procedure. The court upheld Roe v. Wade, but overturned the trimester framework of viability, allowing states to implement restrictions on abortions in the first trimester. So since Roe v. Wade, abortion has been a debated topic in the United States, right? It's debated by several organizations, politicians, and citizens, and arguments get twisted, opinions get mixed, and it can be confusing to figure out where you land on the issue, especially in today's heated and polarized climate. So due to this, I'll go through some current players in today's debate about abortion. So first off, I want to go over the pro-life leaders. So pro-life leaders or anti-abortion advocates. This camp believes that for whatever reason, religious, ethical, or personal abortion, that abortion should not be supported by the government. They are different than the pro-life advocates in that they are collectively against one thing, and that their reasoning usually stems from religion. The campaign for pro-life came out of the equality movement in the 60s to counteract the actions of the pro-choice movement of the time. Since then, it has been supported by notable organizations such as the Catholic Church and has become a platform for the Republican Party. Many of the notable pro-life organizations are smaller than the pro-choice ones, but a very notable one is the NRLC, the National Right to Life. They focus on restricting abortion, keeping the Hyde Amendment, and connecting all of their kind of strings to free speech in one way or another. So some notable pro-life leaders that you may know are Donald Trump, Senator Ted Cruz, and Senator Mitt Romney. On the other end of the spectrum, we have pro-choice leaders. So this emerged from the equality movements of the 1960s as well, and it was furthered by Roe v. Wade in 1973. The pro-choice camp of thought has an established history in the United States. While values differ person to person, as opposed to the pro-life where it's mostly religious or ethical, the pro-choice camp tends to advocate for abortion under body autonomy, which is the right that each person has to govern their own body. Under this, the pro-choice movement claims that abortion is an undeniable right, unalienable right under the Constitution, and cannot and should not be overturned. The most notable pro-choice organization is the NARAL, aka the National Abortion and Reproductive Rights Action League. Organized in 1969, this organization has launched several rights campaigns in support of the right to abort. Currently, the organization advocates for abortion and birth control access, fighting against pregnancy discrimination and paid family leave. Some notable politicians that support pro-choice are Senator Kamala Harris from California, Senator Bernie Sanders from Vermont, and our own Senator Tim Kaine from Virginia. So now that we have kind of gone over the two separate camps, you may be thinking, what's next? What's happening now? Before I go into fully what's happening now, I do want to talk about something very important, and that is the Supreme Court. So as polarization has ripped the two parties apart, there are things that are true. And the Supreme Court makes several decisions. So I did want to go into kind of the importance of the Supreme Court in the relationship to abortion. So these are the 9 members of the Supreme Court. Let me just give you a little bit of a background on what the Supreme Court does first. So as you know, the Supreme Court makes supreme decisions for the judicial United States. To get to the Supreme Court, a case first goes to either the federal district court or the state's appeals court. Then it is either moved up to the federal court of appeals or to the state Supreme Court. From there, it is moved to the Supreme Court. So that's kind of the process. There are 9 members of the Supreme Court, and to make a decision, the court needs to have at least a 5-4 favor, and there are members of the Supreme Court. So here are the members of the Supreme Court and their stances on abortion. So John G. Roberts, Jr., he is the Chief Justice of the United States. He has voted in 2 major abortion cases. In 2016, he voted in favor of abortion, but later he voted against abortion in another case. He claims that his decision for the first case was incorrect and that he has worked to restrict abortion since. So next up we have Clarence Thomas. He voted to overturn Roe v. Wade in Planned Parenthood versus Casey. He is against abortion and has called to overturn Roe v. Wade since then several times. Sonia Sotomayor was appointed as a justice without a history of a voting record on abortion. Since then, however, she has voted in favor of abortion laws. She just hasn't had a lot of chances to. Justice Stephen Breyer has supported abortion since the year 2000. He has written that because the Constitution guarantees fundamental individual liberty and has to govern even when there are strong divisions in the country, this court, in the course of a generation, has determined and then redetermined that the Constitution offers basic protection to women's right to choose. So he believes that the Constitution covers the right to choose. Justice Samuel Alito has a long record of voting against abortion rights. Working with the Reagan administration in 1985, Alito wrote a memo that the government should say publicly in a pending abortion case that said, "We disagree with Roe v. Wade." So he completely is against Roe v. Wade. Alana Kagan has voted in favor of abortion rights. She believes that the precedent that was set by Roe v. Wade should be upheld as it is a precedent. So that's kind of the stance that she comes from. Justice Neil Gorsuch has the shortest record of abortion rulings of the 9 justices, but he has claimed to be against abortion, and in line with his other political views, it makes sense for his platform to be against abortion, so we will have to see what happens next with him. Justice Brett Kavanaugh has not given his opinion on Roe v. Wade specifically, but he has decided that he is vehemently against abortion. He's voted several times against abortion and has stated specifically that illegal immigrants do not have the right to an abortion. And then lastly, we have the newest Supreme Court Justice, Amy Coney Barrett. She has a long history of advocacy against abortion and abortion rights in general. She used to be part of a deeply religious group that was vehemently against abortion, so no one can assume that she, doesn't still carry those values. She said in her trials as well that she will try to uphold her anti-abortion views. So we'll see. So now I'm going to get into 2 really important current cases that are happening right now before I conclude this presentation. So first I want to talk about Texas. There was controversy over Texas's Heartbeat Act. So introduced as Senate Bill 8 and House Bill 1515, this act bans abortion after the detection of an unborn child's heartbeat, which normally occurs after the 6 weeks of pregnancy. 6 weeks into pregnancy, right? So this is halfway through the first trimester, and the law passed in September of 2021. It's the first time that a state has successfully imposed a 6-week abortion ban since Roe v. Wade, and the first abortion restriction to rely on enforcement by private individuals through civil lawsuits rather than by the government through criminal or civil enforcement. As women or childbearing people in general don't typically even know about their pregnancy until 2 to 3 weeks after conception, let alone make a decision after that, there has been a lot of controversy over this issue. It has been challenged in court by several suits, including Whole Women's Health versus Jackson and the United States versus Texas, with a few clauses. And with a few clauses, the abortion law has been upheld and officially put into effect in September 2021. So it is a law that is in effect right now, even though there's a lot of controversy and a lot of fighting over it. And then we also have the Mississippi law. This one is a little bit shorter because it's happening right now. But basically, this is another abortion-related issue that is happening. It's happening in Mississippi. It's basically bringing up a 2018 state law in Mississippi that the law was to ban all abortions after 15 weeks, which is during the second trimester. This includes abortions in cases of rape or incest, so it's very monumental in that way. This law has not yet been passed, but it has brought up again this kind of conversation about abortion, about whether rape or incest should be involved in it, and it is currently being debated on whether or not the law should be put into place or not. If passed, the law would overturn Roe v. Wade in Mississippi and would set a precedent for other anti-abortion states. So it's a very pinnacle law and controversy that's happening right now. So to conclude, abortion has not always been debated on, but due to its complicated history, it always will be discussed in the United States. Unfortunately, there will always be a debate over the rights that women have over their bodies, their children, and their livelihoods. So I would just take with that what you will. Think about where you are on your side of this difficult issue, and in having these difficult conversations, just try to bring as much light as possible. I hope you enjoyed my presentation and have a wonderful day.